nursing graduates, it's Mitch here from Deakin Health.
Hey, I'm Jazz.
Hello, my name is Yasser.
We are your fellow nurses here to assist you with your transition on the ward within the mental health sector. As you are graduate nurses here in the mental health sector of Deakin Health, it is important for you to understand the basics of the legislation that is involved and what it means for you and your patients in your care. Here in Victoria, there is legislation for consumers that are mentally unwell. The legislation falls under the Mental Health Act 2014. The purpose of the Act is to protect the dignity, rights and autonomy of people with a mental illness. It also places the consumer at the centre of all the decision making of their own care. This framework intends to promote recovery-orientated practice to reduce compulsory treatment and inevitably protect and support the rights of the consumer with mental illness. The rights that have been implemented for consumers under the Act include the following. Number 1, making an advance statement. Number 2, having the right to communicate privately with people outside of the mental health services. Number 3, have a nominated person. Number 4, have the right to request a second psychiatric opinion. And number 5, be given a written statement of rights when being assessed. The Act encourages mental health practitioners and psychiatrists to create strong relationships with those using mental health services. It enables them to provide the correct information and support to make informed decisions about their care. The role of the nurse, according to the Mental Health Act, is to follow the guidelines and provide advocacy for the consumer. Recovery and remission is the goal for the consumer, with a holistic approach to nursing care. Practice in this field includes promotion of well-being and health, prevention of ill health and management of risk factors, early intervention, recovery-focused interventions, patient-centred care, chronic disease management and rehabilitation. The key principles for health professionals to note when caring for mental health consumers are the following. Provision of mental health services in the least restrictive way possible, promoting recovery and the best possible therapeutic outcomes, including participation and support in all decision making. When the Mental Health Act is summoned, the consumer must be handed a statement of rights so that they are able to acknowledge their rights throughout the process. Depending on the situation of voluntary or involuntary treatment orders, all consumers must be handed this in writing. During the examination to determine if an assessment order is required for a consumer, this can be conducted in either a hospital or the community. The mental health practitioner or doctor must explain the reason for the examination and inform the consumer if they are subjected to an assessment order. This is when they need to be provided with the statement of rights. A mental health tribunal is a hearing where experts decide if you must have a mental health compulsory treatment order. The tribunal members are a legal member, a psychiatrist or mental health practitioner, and a community member. They are not a part of the health services to ensure that the tribunal is fair in its decision making. The members read the report from the health service, the medical records, and any information that the consumer has provided in order to make their final and fair decision. The next steps that we will cover is the assessment order, the treatment order, and the temporary treatment orders.
Now we'll be going over assessment order, the purpose, making, criteria, and the duration. An assessment order. An assessment order is the first step to initiating compulsory mental health treatment. A registered medical practitioner or mental health practitioner make an assessment order if they have examined the person and they are satisfied that the criteria for an assessment order apply to that person. Purpose of an assessment order. An assessment order enables an authorized psychiatrist to examine the person without the person's consent to determine whether they have a mental illness and need compulsory mental health treatment. An assessment order also enables a person subject to that order to be taken to and detained in a designated mental health service for assessment if necessary. Making an assessment order. This has to be done before a registered medical practitioner or a mental health practitioner makes an assessment order. They must, to the extent reasonable in these circumstances, they have to inform that person that he or she will be examined by the practitioner, explain the purpose of this examination to that person. The registered medical practitioner or mental health practitioner must examine the person before making an assessment order. The practitioner must be satisfied that all the criteria for an assessment order apply to that person before making an assessment order. These are the criteria for an assessment order to be valid. These are such an order: the person appears to have mental illness, Because the person appears to have mental illness, the person appears to need immediate treatment to prevent, such as serious deterioration in the person's mental or physical health, serious harm to themselves or to anyone around them. If the person is made subject to an assessment order, the person can be assessed, and there is no less restrictive means reasonably available to enable the person to be assessed. In determining whether the criteria applied, the registered mental practitioner or mental health practitioner may consider information communicated to the practitioner by a person other than the person being assessed. A registered medical practitioner or mental health practitioner may only make an assessment order within 24 hours of the examining the person. The duration of the assessment order. An authorized psychiatrist must assess a subject to an assessment order as soon as practicable and within 24 hours of the person subject to an inpatient assessment order being received at a designated mental health service or of the making at a community assessment order. A person subject to an inpatient assessment order must be taken to and received at a designated mental health service within 72 hours of the making of an inpatient assessment order, or the order will expire.
To talk to you guys about the temporary treatment order. So today we'll be learning about what a temporary treatment order is, the purpose of a temporary treatment order, how the temporary treatment order is made, and also the duration of the temporary treatment order and the validity of the order. So a temporary treatment order is a legislative regulation under the 2014 Mental Health Act. This temporary treatment order is initiated by a psychiatrist to provide compulsory treatment to whoever falls under the necessary criteria. Treatment criteria involves person being a serious threat to others or themselves. If a person requires immediate treatment to prevent further deterioration, and the person should present with a mental illness that has no other less restrictive options available for treatment. A temporary treatment order can be treated in the community, or the patient can be detained at a mental health institution and treated as an inpatient. When making the temporary treatment order, the authorized psychiatrist must regard the views of the nominated person, views of the parent if the patient is under the age of 16, the views of the carer as this decision may directly impact them, and the views of the person receiving treatment. This should always be recognized. A temporary treatment order remains in force for 28 days, beginning from the date it was made unless it was revoked earlier. Person receiving treatment can at any time make an application to the Mental Health Tribunal in an attempt to revoke their treatment. This will then be dealt by a hearing with the Mental Health Tribunal. Expiry of a temporary treatment order can only be placed at the end of 28 days or if revoked earlier. If the person is made subject to the court secured treatment order, or if the patient is detained to a mental institution following a Crimes Act. The order should also mention whether it's community-based or inpatient treatment. However, a psychiatrist can vary a community treatment order to an inpatient treatment order if they are convinced that the person cannot be treated out in the community. The Mental Health Tribunal must be notified when altering any temporary treatment orders. The purpose of these orders is to provide autonomy for all patients and be able to provide efficient care.
So, what is a treatment order and how does a consumer get put on a treatment order? A treatment order lets an authorized psychiatrist provide treatment to a consumer that meets the treatment criteria. An authorized psychiatrist must make an application to the Mental Health Tribunal at least 10 business days before the end of their current temporary treatment order or treatment order. When determining if the treatment criteria apply, the following must be taken into account: the consumer's views and preferences about his or her treatment and that of their advanced order, the views and preferences of the nominated person or guardian, the carer, if it may directly affect the care relationship, the parent of the consumer, if the consumer is under 16 years old, and the secretary to the Department of Human Services, if the consumer is subject to a custody of secretary order, or a guardianship to secretary order. If the tribunal decides to progress with the treatment order, after the hearing, the tribunal must outline the duration of the treatment order, the setting of the treatment order, whether it's inpatient or community. Keep in mind that an inpatient treatment order only applies if the tribunal is satisfied that the treatment cannot occur in the community. Or they can decide to revoke the treatment order if the tribunal is not satisfied that the treatment criteria apply for the consumer. A treatment order can be made for a maximum period up to 6 months for an inpatient order for a consumer 18 years or older, up to 12 months for a community treatment order for a consumer that is 18 years or older, up to 3 months for a community treatment order or an inpatient treatment order for a consumer that is less than 18 years of age. Variances to a treatment order. The authorized psychiatrist may vary a consumer's treatment order at any time according to clinical need without requiring the authorization of the mental health tribunal. A community treatment order can be changed to an inpatient treatment order if the psychiatrist believes the treatment order cannot be undertaken in the community. When any variations occur, the mental health tribunal must be notified, and if the setting is changed, a hearing must be conducted within 28 days. Revoking a treatment order. Applications can be made to revoke at any time, and the mental health tribunal must conduct a hearing to deem if appropriate when it's practically possible. With your continuing education will come a deeper understanding of the Mental Health Act and treatment order. Happy studying, and most of all, applying.
As you can see, the Mental Health Act is an integral part of mental health care. Thank you for watching this educational video, and we look forward to seeing you on the ward. If you would like further information, you can head to health.vic.gov.au